Hey everyone, it's been well over 2 minutes and I haven't been raped yet. Now, let's deal with some other nonsense. Hi, I'm Diana Davison. Now, one of the reasons I became a civil rights activist is I hate being lied to. It makes me very angry. So this week I'm going to talk about an article published by Andre Marin in the Toronto Sun about a week ago, at the beginning of July, telling the public to pay no attention to a dangerous bill that is now past second reading in Parliament. It's a bill that will destroy any meaningful defense against accusations of sexual assault. Generally, when someone says,
"Oh, pay no attention to that man behind the curtain,"
it's time to take a closer look. Now, before we get to the legal fiction of the article, let's have a look at our author. A basic Wikipedia search does the trick. Mr. Andre Marin, during his tenure at the Special Investigations Unit, he was sued twice by police officers for malicious prosecution. In June of 1998, appointed Canada's first military ombudsman, Marin had created a dysfunctional workplace at his office during his tenure. In 2010, the Toronto Star investigated human rights and labor complaints made by staff under Marin's tenure. And there was also a controversy over billing fraud at taxpayer expense. Now, keep in mind, this is just the stuff that made it into Wikipedia, okay? Marin developed a reputation for an aggressive use of social media, including sometimes using personal attacks and grandstanding. Some members of the press have criticized his judgment and impartiality. Well, as it turns out, Marin's balls aren't quite as big as he'd like you to think. Without ever having tweeted at him, I was already blocked on Twitter.
Really, I cannot hold any grudge towards him because I would not want to face me either.
Damn, I'm having so much fun I almost forgot about the article. Okay, so let's have a look at this legal heavyweight, who unfortunately is actually a part-time professor at the University of Ottawa. Who wrote this crap? That's the first sentence of an email response I received from a member of the legal community. Now, lawyers sometimes have problems explaining legal issues to members of the public because they have a fondness for legal phrases like res judicata or habeas corpus or calling their adversary my friend. So let me put this to you simply. Bill C-51. I'm going to give you a before and after example. Before, girl lies and says something like, "I had no romantic interest in this dude." Dude says, "Here's an email where she proposed marriage," or a love letter that she sent to me. Court says, "We find the witness was reckless with the truth." The accused is acquitted. Now, see how that works? It's pretty simple. It's basically the primary way that you expose somebody for lying in court. So here's an example of what it would look like after Bill C-51. Girl lies and says, "I had no romantic interest in the accused." Dude has to make an application and submit his email and love letter to a preliminary hearing before trial. Girl changes story to say, "Well, I was afraid of what he might do if I confronted him about the assault, so I sent him a love letter." Expert on rape trauma is brought in to court to explain why rape victims sometimes propose marriage to their rapist. Expert goes even further to say that in fact, the marriage proposal is consistent with and tends to prove that the girl is a victim of rape. Dude gets wrongfully convicted. The law is now adjusted to include marriage proposals as a sign of rape. That's what this would actually do to change the law, but this is what Andre Marin says. It's received scant attention because it's merely the case of legislation being updated with the times, particularly technology, to modernize the already validated but dated rape shield law. Well, that's a lie. Marin then goes on to talk about a case called R versus Derrick, which he was personally one of the assistant district attorneys on, and he does this so that most people will just glaze over and trust him to tell them what they need to know.
Look at him as a novice, he throws an overhand right, he looks at the floor, closes his eyes and hopes for the best.
As my legal friend wrote, somebody needs to respond to this blatantly dishonest propaganda. The defense of the proposed law is almost as scandalous as the law itself, and if it weren't so politically correct, it would be grounds for an investigation by the Law Society for conduct unbecoming. Using your authority as a lawyer to lie to the public is a disgrace. Now, National Post columnist, who is one of the subjects of attack by Andre Marin's article, has written a response which was published this morning in the Toronto Sun, and I want to congratulate the Sun for granting her that space for rebuttal. Heavy hitter and slugger Barbara Kay defends her article with real examples and finishes with the following. One can easily see why prosecutors and former prosecutors like Marin might approve of this amendment, since it makes the Crown's job easier. But if C-51 is adopted as is, we will likely see a rise in wrongful convictions of defendants, near invariably male in sexual assault cases. Marin has trivialized the important issues at stake here. His seeming contempt for thoughtful, evidence-based responses to an ill-conceived attack on an accused's fundamental right to make full answer and defense does him no credit as a polemicist. Well, I'm going to go one step further. Marin's conduct does him no credit as an officer of the court, and it should be met with complaints to the Law Society. I'm writing mine tomorrow, and I know another Canadian who's already composed his complaint as well. So I'm putting all the information you need to file your own complaint in the description below. Please open that up and have a look, but only if you're Canadian, please. Just only Canadians can make complaints about a Canadian lawyer. So that information will be below. Now I've put an example of what you might include in the body of your complaint below, but I'd also want you to understand that R versus Derrick in 2000 did not establish rape shield law and the so-called twin myths. Those myths are that a woman's previously having sexual experience does not make her less credible, and it also doesn't mean she's more likely to consent. But in 1991's CBoyer decision, the important thing is that it recognized that this rape shield provision should not bar legitimate information from court, and it needs to be watched closely. In fact, if you don't watch it closely, it will creep forward and it'll start barring evidence that is relevant from court. So instead of Bill C-51, what we actually need to do is we need to have some way of preventing that from happening, and instead what they're doing is they're trying to prevent another Beverly McLaughlin decision that prevents them from expanding what's covered by this law. So that all said, I want to give you a practical example of what may be barred from court but is completely relevant.
He might get mad. Where's he at? What's he gonna do?
It's important to know that the defense doesn't necessarily know what evidence they're going to use until they hear what kind of lies the accuser is telling in court. So some things that could be barred, I'll give you a really good example. Say a complainant says that they have never met this person before or never had sex with them before, and the accused can prove that they have. Well, that is evidence of previous sexual activity, but it's not being used to say that the woman's a slut who can't be raped. It's used to show that the woman has taken an oath to tell the truth and is willing to lie. So it has to do with credibility. In the case of CBoyer, what was barred from court was evidence that the woman had had sex with somebody else within 24 hours prior to the event under question, and that she was claiming bruises came from him, and he wanted to say that the bruises could have come from somebody else. And Chief Justice Beverly McLaughlin agreed for a very important reason.
Sit on my lap. Don't go first.
One of the most underestimated effects of Bill C-51, if it was to be passed, one of the things people don't want us to talk about, is that if the defense, unlike any other accusation, if the defense against a sexual assault allegation must reveal their defense evidence to the Crown, the prosecutor, in advance, they are being forced to participate in their own prosecution. It violates their right to silence. It'd be the only accusation in which that right is forfeited. So why does Andre Marin not want us to talk about this? Why is Andre Marin so vehemently opposed to an honest discussion of this bill that he's willing to lie to his country and lie about the law as an officer of the court? One thing I can tell you is what should happen as a result. Andre Marin needs to be investigated by the Law Society of Upper Canada. Let's make it happen, people.
There's no emotions in it. I have no problem with him. I'm gonna slap the head off him. It's business as usual.